Well, good afternoon, everybody. Hi, I'm Neil Kalin, joined as usual joined by Michael Simkin. And we have a special guest today, Fred Trester, who is going to help us out. And we're going to interview him and find out about his practice and his life. And we're going to get started just a moment. We just opened it up, so we want to make sure that those who signed up have a chance to log in because as of last month, these What's Up With Us webinars are available for MCLE self-study credit. So we'll talk about that in just a minute. Looks like our numbers have stopped going up, so we're ready to get going, right, Mike?
Ready and willing and able.
Great, great. So we have a overly ambitious agenda today. There's no way we're going to get to our last case. Fortunately, Fred was able to make it today. He possibly was going to be in a deposition, and good for us, he didn't have to be. So we're not going to make it through all cases today. But what we don't cover today, we'll cover next month. So what's up? Well, it's our post-President's Day edition of What's Up With Us, the real property law section, really summary of relevant cases that affect real property law practitioners. You can see what our cases we're going to talk about today. Well, we're going to start with Greenspan versus Los Angeles. That has to do with uh, property tax valuation. Then we're going to go into Campbell versus FPI management and whether low-income tenants have standing to bring a class action for an improper termination notice. We'll interview Fred. We'll go into D. Martini, which is Liz Pendens case, something that we don't cover very much here on What's Up With Us, but I thought this one is going to be relevant to our practitioners. And I'm sure we're going to end up with Romero versus She, dealing with implied easements uh, as opposed to express easements, right? So we're going to get into that. So let's start off with what are we talking about here with post President's Day? Well, so I thought we'd start out with this, which is what do you, our What's Up With Us listeners, have in common with U.S. Presidents George Washington and Abraham Lincoln? So you're probably thinking, what do I have in common with them? Although they led absolutely fascinating lives. Well, self-study. That's what you all have in common with two of our most famous presidents here in the United States. So I thought I'd pick out a couple of quotes with one about George Washington I found from the Britannica website. His best training, however, was given him by practical men. That would be us, Michael, you and me and Fred as well, not by books. And then Abraham Lincoln, well, he educated himself, right? And I think that is well known that he was a self-educated man. Again, those who just joined a little bit late, the What's Up With Us webinars are available for 1 hour of self-study, MCLE credit. Those of you who have registered, you will be getting an email following the presentation. It might go out tomorrow, I'm not really sure. That will have a copy of the materials as well as a certificate for your self-study credit. So great, keep that. It's nice to be able to earn some MCLE credit. Keep them, save them, whatever, download them, put them in a file, whatever it is. Nice to know that you're interested in educating yourselves. So let's jump right in then because we got a lot to talk about today. Let's jump right in with Greenspan versus County of Los Angeles. And Michael, I don't remember, were you going to start with this one or did you want me to do it?
Well, this is a pretty simple one. I don't mind. I can talk about it.
Okay, great. Go ahead.
Okay, so this is what I would call a base Proposition 13 case. Okay, that's all it's about. It's about when you buy property, it's assessed by the county tax assessor. If you improve it, it's supposed to be reassessed by the county tax assessor. We know that occurs usually when building permits are obtained or when there's a change in title. So one of the things, how I go on these like side rants here. So when you have the parents say, oh, I'm going to add my child to title for whatever reason. Guess what happens? County comes in and reassesses it, and then you have this whole issue. Then you have the issue about how to undo it a little bit. Then you have the some statutory exceptions, like a parent to child exception. Does it get reassessed or not get reassessed? And is there a maximum dollar amount that can be reassessed or not reassessed? All this sort of stuff. And then when you have these disputes, you end up at the Assessment Appeals Board, which I've dealt with a little bit. It's an interesting tribunal, and they have like the formal way, and then they have the informal way, and they try to like do what they want to be done to you. But in this particular case, the homeowner got really upset. They said, what the hell are you guys doing here? I bought this house, and yeah, I tore it down and I left the garage there. But why are you adding the cost of the house to the new cost after I built the home? And I have this high tax bill now, although you graciously deducted the cost of the garage or the value of the garage, which, you know, remained as a original garage, I guess. And these people, they went through the whole process. It's a quite a ordeal to appeal the, you know, to do these appeals, including filing a lawsuit. And the court didn't go along with the property owner, so then it got appealed, and they did win eventually. And when they looked at the codes, Proposition 13 and the Revenue and Tax Code 51, I thought it was pretty clear. Like, to me, this is a no-brainer case here about how this should have been allocated. And the property owner did win in the end. And what happened was essentially, under the Revenue and Tax Code, they said that the value of any structure removed by a homeowner is to be deducted from the prior base year value. So when the new construction was completed, and then they appraise whatever they think is that new construction, and they have a very complicated way of doing that, or simple, depending how you look at it. The appellate court said they have to redo this. They have to back out that house that was destroyed, because that under the statute has no value. Okay, it's removed. So you look at the value of the new structure. To me, that this is pretty easy. What do you think, Neil?
Well, to me, the not easy part of this is on your screen. If you look at that very last paragraph, what the appellate court said the problem was here was that the assessor automatically took the value of the property and added the old property, the property that was demolished, and added it to the original land value, because there was a policy procedure in place that said, oh, if this is done in 2 years, that the assessor is going to make a presumption that when the property was first bought, that it was bought for land value only, as opposed to, you know, land and improvement value. And I thought the court was, you know, very generous here in one of their statements that said, well, the problem here was that there was an automatic adjustment, but the assessor could have looked at the situation, actually looked at the factual situation, and then made a determination if the original purchase really was land value. Now, the property owner here who challenged the reassessment indicated that they had no intention of tearing down the whole property when they bought it. So they were not buying the property for land value only. They were not buying it for land value only. That really was irrelevant to this case, because this case, the assessor said, well, we just have this automatic policy. If there is a demolition within 2 years, we are making the assumption that the original purchase was for land value only. So had they not made that assumption, had they actually gone in and done an investigation, it's possible there would have been a different result. There would have probably been a different challenge by the property owner, because the property owner indicated, no, they were going to do some remodeling, but they did not, when they purchased, originally intend to bring the home down to the studs in order to build something completely new. So I think the appellate court said, there is a little bit of an out here, but you just can't have this automatic rule. So to me,
Yeah.
that was the most interesting part of this case.
And the other
It's
thing,
not-
just one point, Fred.
Oh, go ahead.
Go ahead. One thing that's important, and I know Fred will agree, when you're a trial court attorney, the facts are critical. So like you mentioned, there was this presumption and an automatic reassessment. Well, these people bought the house in March 2014. They didn't do their construction, apparently, until February 2016, okay, about 2 years later. So they actually really did wait. While most people start tearing it down, within a few months, they waited about 2 years. So when the appellate court's looking at the facts, because all judges, it's always the facts. The facts are what matter. And so that clearly supported their argument, about this policy.
And Fred, before you get to your comment, had the homeowner waited 2 months to tear down their property, there never would have been a case at all. Fred, go ahead.
No, I was just going to say, to me, this case looked like a double dip by the assessor because they were just adding on the original house and then the new house. So, that just seemed unfair. And I thought that's why it would go in that direction too. But, one of the things Michael said about, there's transfers from parents to kids of a home. And I was reading the other day, many of you may know this if you do any tax related work, but you transfer it to your kid, there might be a reassessment. But the other problem potentially is that if you transfer it while you're still alive, then the kid's going to get your basis for it. Whereas if you wait until you die, the basis goes up to market value, and then the children will not have to, if they sell it, pay a huge capital gains. That's an aside.
It pays to get good advice whenever you're dealing with a real property transaction, right, Fred? Isn't that the bottom line advice here? There's tax advice, there's income tax advice, then there's property tax advice, and you got to look at both elements.
Absolutely.
All right, great. So there we go. One of you two can look at our question. I see somebody wrote something in, and then I'll move us along to our next case. If you guys look at that, if you want to start before we start talking the next case, great. If not, we'll get to it later. I'm not hearing anything, so we're just going to start talking about.
Well, we can answer the guy's question. Okay. About an expert. You need to whenever you do these tax assessment appeals, it is the appellant's obligation to have some evidence as to the value. So often you might have estimates from a contractor that says, I gotta completely tear down this section of the house because there's mold, or it's from 1918. So even though I paid $12 million for it, all the plumbing has to be changed, the electrical changed. It's really not worth that. It's not really habitable. So you can do that way. You can have an appraiser give you a new appraisal, or bring the appraiser to the hearing. So yeah, you have to do that. That's a burden of proof that you still have to persuade the assessor that the property is not worth what they're claiming.
Okay, thank you, Michael. Like I say, always love having you who has the practical experience on these What's Up with us. Good, so let's move on. We're going to talk about Campbell versus FPI Management, decided in January of this year. So let's kind of look at the facts of this case. We have a class action lawsuit that was brought on behalf of generally low-income tenants. And there was really two different groups of low-income tenants. Those who were renting property that was part of the Home Investment Partnership Program, and tenants who were part of the Section 8 program. And they're very different programs, right? Section 8 provides money to a property owner, to a landlord, to help the tenant pay for the rent. Now, for the Home Investment Partnership Program, what that is that the government gives a builder developer money, and in this case, lots of money, to build units in the first place, provided that the builder developer is going to rent out properties to low-income tenants and abide by the rules that are established by the home program. Okay. So here we have the situation where various tenants did not pay their rent. The property management firm on behalf of the owners, the property management firm was FPI, served the tenants with a 3-day notice to pay rent or quit, started the unlawful detainer process, and eventually the tenants did move out. Many of them were given extensions. They did not move out, after 3 days. Some of them were given multi-month extensions, but eventually the tenants did move out. And then what happened afterwards? Well, the plaintiffs brought a class action lawsuit alleging that the failure to give tenants a 30-day notice to quit violated the unfair competition law, right? So violating the UCL would establish some grounds. There was a breach of another law, and that created the grounds for them to be able to establish their class action suit. So went to a trial. What happened here? The trial court granted the defendants, no merits motion, saying, wait a minute, there's nothing of value here that this should not have been granted. And then as part of that, the trial court said, well, Section 8 plaintiffs, you're not entitled to 30 days notice. And home plaintiffs, this is interesting, you lacked standing because they remained in the property for at least 30 days. So basically the court was saying, hey, no harm, no foul. Even if you were entitled to 30 days notice, you were there at least 30 days after you were given the notice. So what are you complaining about, home tenants? You got to stay there for at least your 30 days. The plaintiffs appealed the decision. And what do we have here? The court looked at the situation. The court looked at the two groups differently. And for the home plaintiffs, the court said, well, when you're taking government money and you're agreeing to build a property subject to the terms of that government money, and part of those rules say you must give the tenants 30 days notice to terminate the tenancy, you, property owners, you did not do that. So there was a violation of the rules here. Now, one of the arguments the property owners were making, they said, well, wait a minute, that's inconsistent with state law that allows a 3-day notice to pay rent or quit. And the court said, the appellate court said, no, it's not really inconsistent. You could read those two things together. In other words, you could have given the tenants a 30-day notice and then 27 days into that notice, given them a 3-day notice to pay rent or quit. So the court said, yeah, you know what? There is a violation of the Home Act, right? Which is sets the ground for unfair competition. Now, how were these tenants damaged? And the court said, well, they were in legal peril. They were in legal peril because their tenancy was terminated 3 days, and I want to hear what Michael has to say about this. Their tenancy was terminated 3 days after they received the 3-day notice to pay rent or quit. So, Michael, we're going to get to your comment on that in just a minute. But even if that's the case, if there was an agreement allowing them to stay there for 60 days or 90 days, how were they in legal peril? And the appellate court was really kind of theoretically saying, well, if they're no longer a tenant, they don't have the same rights as other tenants, and somehow that harmed them or potentially harmed them. So therefore, we're going to allow the cause of action to go forward with the home plaintiffs. And then dealing with the Section 8 plaintiffs, the court said, guess what? There is no statutory or case law that mandates that the Section 8 tenants be given 30 days notice. Therefore, we're going to dismiss those claims. So, Michael, I really want to hear what you have to say about this, especially the legal peril, argument that the appellate court made with regard to the home plaintiffs.
All right, this is my take on this case. And I like these types of cases because it tells you what not to do on both sides. So this FPI, I've seen them come up a lot. They're a pretty aggressive property management company. Anyway, the legal issue here is really what was the injury in fact for the unfair competition standing? Okay, what is the injury in fact? So the court broke it down, basically said violation of a law, okay, is what you need. And then they kind of start stretching stuff about what was the injury. But I want to point out a couple things. Like I said, you have to choose your battles and choose who are your soldiers. So when you do a class action, I don't understand why the plaintiff attorney for the tenants, why the tenants decided to have two distinct classes, the Section 8 people and this Home Act people. They're very different. And in the end, that's what the court said. They said Section 8 people have a different law here, different outcome. Home people, different law, different outcome. Okay, so if you're going to be the plaintiff, attorney for a class action, choose your clients carefully. Okay. This whole 3-day notice thing and staying in possession for 30 days, that is the biggest crock. Okay, that is so bad. And I think that the appellate court it really pissed them off. The appellate court, though, did get kind of creative with or stretching some of these issues about the termination of the tenancy and loss of property rights. The appellate court made it really clear there's a loss of property rights here because they're saying that if they didn't have the 3-day notice, which was for non-payment of rent, by the way, all these, it's maybe not clear, but it was for non-payment of rent, that the appellate court said they would have enjoyed, this is a quote, the full panoply of property rights associated with a lawful tenancy. It's a little bit of a stretch by the appellate court, but they're saying that if they would have had the full 30 days, then they have, this is a quote from the case, they would have been entitled to quiet enjoyment and exclusive use of their properties. They would have been free from the risk of losses to their own personal property that may have been caused by the negligence or nuisance, and from the imminent threat of liability to the landlord for the value of property and other damages. It said, this I believe in, they could have located alternative housing without the cloud of an imminent eviction proceeding. And then all these things were denials of property rights to give them their standing under the UCL. And I don't quite go with that. I think what happens is even with the 3-day notice for non-payment of rent, the tenant becomes a type of a holdover tenant. Forfeiture requires the unlawful detainer court to declare forfeiture. It's a court of equity, it has to be declared. They still have rights. For example, I don't know where the appellate court came up with this idea about loss of quiet enjoyment and exclusive use of their properties and other things. But if you're in the middle of an eviction, the landlord, for example, can't turn off the utilities. They can't. Right. There's a flood, or I don't know, something happens. They can't create a breach of the warranty of habitability or not make a repair. That's, imagine there's whatever happens, you don't lose those rights. So I don't know where they came up with that. So appellate court, nah. I don't get that part. But what I do get.
Michael,
yeah.
Michael, before you move on from that point, I was noticing when I was looking at this case, and for those listeners who are going to read the case, when you look through the court's reasoning right here, and I don't know that I would have come to that same conclusion either, Michael. But if you look at that, the court cites, for the most part, really old cases. I think they might have had 1 or 2 cases that might have been in the 1990s. Okay. But for the most part, they're citing really old cases to draw the conclusion that they drew. Now, maybe those cases never were, overruled in any way. But to me, it was kind of interesting that the court had to look pretty far back in order to support its conclusion. Go ahead, I'll let you finish.
Yeah, I think the court is trying to find support for these really basic arguments that have matured in the last, 40 years or more. The other thing to point out is I noticed that this was the 5th amended pleading. It's, it's pretty common to get to the 3rd, kind of like the 3 strikes and you're out rule. but the plaintiffs were allowed to, plead this case 5 times. There were, 4 amendments given, which is a little bit unusual. So the trial court is bending over backwards. But I don't understand this concept here with the Home Act tenants. The Home Act in that Title 42 of the USC section 12755 is so clear. It doesn't differentiate between a 3-day notice for non-payment of rent and any other notice, with the small exception about if there's a direct threat to like personal safety of a tenant or someone, like personal safety. It says very clearly, an owner shall not terminate the tenancy of housing assisted under the subchapter, except for the serious and repeated violation of the terms and conditions of the lease. Okay, and it says in the next sentence, any termination must be preceded by not less than 30 days notice by the owner, written notice by the owner specifying the grounds of the action. Okay, that's really open-ended. To me, there's no way, if you're under the Home Act tenant, you could terminate this less than 30-day notice, even with the 3-day notice for the rent. And they also have this whole discussion about, well, is this like a implied preemption of the state 3-day notice for rent law? And the appellate court actually went into that a little bit, which is also kind of creative how they went into that argument. But it just shows you gotta, your claims, having the Section 8 people that didn't have the protection of that 30-day notice, and these Home Act people, I just wasn't like smart, from the plaintiff's point of view. I thought it was also entertaining. There's always the emotional component of every case. The facts count. Every case is about the facts. Okay. I was actually explaining this to my daughter a couple of days ago, that when you're a brand new lawyer, everything seems black and white. 1 + 1 = 2. Pretty soon you realize 1 + 1 does not equal 2 in court. Okay. It's all about the facts. And there's a lot of stuff that goes on. And as you go up the ladder, trial courts try to do the 1 + 1 = 2, and they try to find, like they did maybe they did it in this case in an outlying trial court, I don't know, find cases from 50, 60, 70 years ago. But at some point, someone stops and looks at it and says, we're dealing with people, and these people got screwed, or these people being taken advantage of, and what can be done? And there's so many cases floating out there that you start putting together the pieces to get what the result is that they think is just, right? Just. And when the FPI landlord here is trying to blame the old property manager that was there for doing the notice, that's not going to work. You can't say, well, we're just the property management company. We're not the owner who signed the contract with the home company to get millions of dollars of funding to buy this property and develop it. They're not going to go for that crap. Okay, so it's really important, the facts and what's going on here. Okay, and how these people got kind of screwed, Anyway, what do you think, Fred?
I think that whenever you are dealing with landlord tenants in California, you better be very solicitous to your tenants, because the weight of, or most judges and appellate courts and local jurisdictions, especially LA and San Francisco, are going to be, I think, pro-tenant. I mean, as a landlord, I'm very careful about everything I do with tenants. And if they push back, I usually say, no problem, let's just move on. And so I think these people at FPI were a bit less than educated in what they should be doing. I mean, we had one case where there was a lawsuit about evictions because they wanted to, improve the property, and they evicted immigrants who were in there, and that was enough to bring a federal court action. One of my former partners tried it, and they hit the management company very hard on that. And so I just say be very careful with dealing with tenants. And the other thing this brings up in my mind is, if you're ever dealing with credit reporting with tenants, just be careful with that too. I mean, we had another case where our property manager client didn't check a box on a form relating to credit checking, and that was enough to expose them to a mandatory $10,000 fine. And these are people who are like homeless, and they were being put into apartments, and a lawyer got a hold of it and saw the technicality, and he went around and interviewed tenants and brought like 30 different cases for this. Unfortunately, we were able to show no damages, but it was a knockdown, drag out fight. So just be careful when you're dealing with tenants in California.
So one thing, another item that I thought was kind of interesting here is the court said we're not going to talk about damages. That's for another issue. That's not before us. But when I saw that, statement in the case, it made me think about, and it would be a completely different issue. And I don't know whether anybody, has the stomach or the finances to keep fighting this. But I'm wondering if the named plaintiffs were really good class representatives, right? Because the damages all seem to be theoretical, right? That this might happen because you were given 3 days instead of 30, or that might happen, or that might happen. Michael, you said, what if there's a flood? What if you can't find a place to live? There was a whole bunch of what ifs. And so I'm wondering if the named plaintiffs are really representative of all the members of the class where these things may have occurred or may never have occurred. But that's for another issue. It just made me think about something else as I was looking at this case, not directly dealing with landlord-tenant issues.
Well, remember,
all right, so that's good. Go ahead,
last point. Under 17,200, you're not entitled to damages. You're entitled to an injunction and restitution. So here, I suppose that really we're seeking injunctive relief to prevent them from doing it and prevent the evictions. And you potentially get attorney's fees if it's essentially a PAGA type claim. But so that might be why it didn't matter who the plaintiffs were for that purpose in terms of where the damages would be.
Yeah, they could be, but my impression from this case is they were already out. They're already gone. So it wasn't a matter of stopping the eviction. The tenants had already moved out eventually, whether by agreement or whether by voluntary action at some point in time. In any event, a lot to look at, a good case for our audience to read. And let's move on. And Fred, now we get a chance for you to talk about yourself, right?
Hey, that's me. When I had a lot more hair on my head. And so I still it's like a lot of real estate agents, they use pictures of themselves when they're like in their 30s and now they're like in their 60s. And so I'm taking advantage of that practice. So I have been litigating broker and buyer-seller defense, primarily defense, although I've handled some plaintiffs related stuff for the last 43 years. I've also been a broker for about 40 years and advised brokers in terms of practices, best practices. I'm currently serving as an expert witness on standard of care issues relating to real estate related matters. I was an adjunct professor at Southwestern Law School where I taught their real estate transactions class. So I have a pretty good background, and that's why now that I'm shifting, although I still do litigation, I am shifting more into mediation. And I was going to just tell everybody, especially younger lawyers who want to really fight, you got it. Good lawyering is knowing how to be efficient and really let your clients know, especially private clients, how expensive litigation gets. Because, I've done a lot of insurance related work, but when there's no insurance and suddenly private pay clients are getting bills for $10,000, $15,000, $20,000, even at a lower rate, it's very challenging for them. So I like the fact, everybody should know that the CAR-RPA has a requirement that you mediate before filing lawsuits. Some lawyers still don't know that. And it's actually could be viewed as malpractice if you don't demand mediation or if you don't accept mediation if the demand is made. And so that is an important thing. And, a lot of people say, well, we'll check the box and we'll go to mediation because we need to preserve our rights to attorney's fees. But that isn't the attitude you should go into mediation with. The attitude should be, how am I going to resolve a case early for my client and get the best result I can? And some of that might require some compromise. Remember, mediators don't make decisions. They're not the arbitrator, but they do assist you. And especially where my value comes in is because I've handled probably or supervised close to 1,000 cases. I pretty much know where the thing's going to end up. I mean, unless it's a very unique situation, but there generally is cases I've already seen. I know where they go, and I can assist. My style of mediation is facilitative in the beginning, where I will lay out each side's respective positions. And I'm also looking for, okay, what's underlying the position? Is there an interest that needs to be dealt with? Is somebody looking for justice? Is somebody embarrassed because they let their family down? I mean, you got to approach it from not only what the arguments are that lawyers are making, but also really what's behind it all. And so my suggestion is get into mediation early. I mean, if you need to do a little discovery, I mean, assuming you can't get it resolved before and you go to mediation and it fails before, back. But a pre-litigation mediation, I'll get evaluative in the mediation, and I will let the parties know. And I'm talking about the parties. I mean, lawyers actually have a good idea. Some lawyers are very aggressive and they want to advocate. They want to show that they're fighting for their clients because a lot of clients want to see that. But a good lawyer is going to do what's best for the client, because at the end of the day, you know, even though you get to trial, you may end up resolving it on the courthouse steps, but you've already spent $100,000, $200,000 of your client's money, which makes it much more difficult, and it becomes a law of diminishing returns at that point in time. And I tell people too, you know, if you get into a deposit dispute over $50,000, let's say, you're going to invest $100,000 to collect the $50,000. Or if you have, you know, some of the cases are a little harder. I mean, one thing I'll tell you right now, all of you should be smiling. Why? Because it's raining outside. And what does rain bring? Landslides, leaky roofs, leaky windows. I mean, my own house right now, I had the roofers out here because my roof in my house was leaking. I fortunately got it fixed in time before these rains started again now. But that is it starts raining, you're going to get calls. And those are the cases that are a little harder because mold can develop. And now you're fighting about what's it going to cost really to fix this property. And then you got people who, you know, you got to really look at it, especially on the defense. What are these people really dealing with? I mean, these are homeowners that suddenly have an uninsured problem that they have to get resolved. And if you know, especially if you were representing flippers who come in, and this is, you know, I'm very happy to see the legislative change where they're requiring starting July 1st, that if you flip a property, you have to disclose it was a flip. You have to disclose what you did, who the contractors were, what permits you got or didn't get, so that people will know that going in. Because if you're, you know, a lot of flippers go in, make the house look great, but they don't really deal with some of the issues like a leaky roof that may have happened before, or windows that are not particularly waterproof, or there may have been foundation issues that they didn't resolve. And believe me, I'm sure Michael's gotten these cases, and I get them all the time, where especially with the flips, they look very nice. They're beautiful. They put in nice granite countertops in the kitchen and the bathroom. Sometimes maybe they upgrade the plumbing. Sometimes they don't. Usually they don't do a whole lot to the foundation. And some of these homes are 100 years old, like my house. You know, the foundation is not going to be to today's standards. And then the people who have to fix them, suddenly the city comes out, well, you need permits. And by the way, now we want you to bring it up to current codes, which is very expensive. So my suggestion again is, you know, be empathetic to who's bringing the claim and recognize that they are people who have to incur a lot of expense. And the earlier you can help them get out there and be proactive with getting the matter resolved early, the better it is for your client. So that's my philosophy as a mediator. I think on my mediation profile, I put down there that litigation, unlike good wine and good cheese, doesn't get better with age. I mean, it really doesn't. Because what happens, and this is really true, you get a month away from trial, suddenly the plaintiff's lawyer is figuring out everything. They're figuring out what the measure of damages is. They're figuring out all the nuances of their case that maybe they didn't think about before. And so you have a better opportunity early on, not to say plaintiff's lawyers aren't good and know what they're doing, but sometimes, like I said, you get close to trial, things are coming up that you didn't even think about, and suddenly you're having to face it. And the real interesting thing is, and this is for maybe younger lawyers who haven't tried cases, when you're in trial, suddenly you're going, oh my God, my witness didn't do so good today. And people say you have good trial days and you have bad trial days. The good ones are where your witness is great, or you do cross-examination and you kill the other side. But then you have those bad trial days where your client just like stumbles. I mean, I had one case literally where one of my former partners at a former firm was a witness that I was calling because it had to do with whether there were disclosures of a prior lawsuit that he was involved with. And I knew that the plaintiffs had checked out all those prior documents. So I called him as a witness, and he came in and literally his voice was shaking. He was like, I'm going, God, the jury's going to look at this guy like he's the most uncredible guy ever. And so those are things you've got to anticipate, that jury trials become like very uncertain. So I bring that back to mediations. That's where you get certainty. That's where you can get peace of mind for your clients. Because obviously, especially like if you're defending brokers, I always say the stress of being in litigation will impact their livelihood. I tell people that at their risk management seminars. I go, once you're dragged into a lawsuit, you're waking up, 3 a.m. and you're thinking about it. And suddenly you're not as productive as you were because, I don't know, I call it, time consuming. Someday you may have to sit with me for 2 weeks while trial's going on and you're going, I got listing appointments. And I'm going, yeah, the jury's here. They're going to wonder why you're not. So you're staying here. And so people need to recognize it's a time commitment. It's also, like I said, emotionally stressful because they're thinking about what's my downside. Even if they have insurance, it's still a scary experience. And plaintiffs too. I mean, the other thing is, if you're a plaintiff's lawyer, yeah.
Brett, this was like the least interview we've ever had on What's Up With Us. It's nice to know that he has so much to say, but I can just tell Michael, I'm sure, has something he wants to ask you, and then we're gonna start moving on to some of our other cases. So Michael, go ahead, pretend this was actually an interview and ask a question.
Like I met Fred being adverse to him in a case, and I was listening to him and like, this dude knows his shit. It's like he really impressed me. but anyway, I know it's okay. But Fred, you said some magic things that I want everybody to like hit him in the head. Car forms, Neil, are amazing for the concept of early mediation. And just like Fred said, you want the mediation to occur and the case to settle before either side realizes the good and the bad about their case. Okay, it happens all the time. I have a case right now that I made a proposal to settle the case like, I don't know, 2 years ago. But now the other side, the defense, is willing to spend at over almost $200,000 more, because as time progresses, more things are discovered, not just facts about problem, but about the litigants and the law. And if you settle the case early on before either side knows their strengths and weaknesses, it settles a lot easier for a lot less money, and impact on both sides. That's critical, okay? So I'm glad you mentioned that, Fred, and I'm gonna keep on talking for a minute. And I want to ask you the one question. What do you think is a primary cause for litigation or disputes amongst people?
Oh, well, as you continually emphasize, which I think it's good, it's you got to focus on the facts. And I think people get upset. I mean, it's funny. I don't know if you're like this, but I'm like the cobbler's kid. When it's my problem, the last thing I want in my life is litigation. So I think it depends on the person. I think there's some very litigious people out there. And I think there's people who really don't want to be involved in litigation, but they have no choice because they have damage and they have to address it. So I would say that the primary cause of litigation is legitimate disputes over money. And some of it has to do with principle. I always tell people it's the principle. And I say, good, you're my favorite client because I'm going to make all the money and you're not. But I don't know if I answered your question. I'm like, by the way, Neil, I just want to comment. I'm like we always tell our client in deposition, just answer the question. Don't go on forever. I'm like the worst example of that. You asked me one question. I went on for like an hour, but anyway. So
Well, we
did
do
I
have a
answer your
case,
question, Michael?
but we have a case that we're going to talk about probably soon, where neighbors are fighting over something that neither neighbor caused, but one neighbor got really aggressive. The opinion even talks about how aggressive they were. One neighbor asked for $300,000 of damages, ended up basically losing, although the court had an equitable easement for like $69,000 of damages, but gave an implied easement, which would be $0 of damages. But these people were fighting over something that neither one caused, and they're neighbors. They have to be together. And what they're fighting over, from a practical point, neither one had an expectation, say, of having this land. So some people fight because they want to fight. And I don't understand that. It's just something that comes up,
Well, I find, neighbor disputes are some of the most, these are the most aggressive lawsuits. Divorces, neighbor disputes, HOA disputes, and those people get so emotionally committed. And I had a case very similar to that easement issue where my client built their driveway onto the neighbor's property that the neighbor didn't even use, and a part of the driveway. And so, you get in, you'll talk about that case, but I think people get very invested in being right. And they will spend a lot of money to be right. And it makes it troubling. It makes it difficult.
yeah.
Well, Michael, why don't we skip right to that case? So I'm gonna go. First of all, thank you, Fred, for that somewhat interview. But you shared so much valuable information. It did not matter that we did not ask the questions because you answered whatever we would have asked you anyway. So thank you for that.
I knew what you were going to ask me, Neil. I've known you so long.
Right. It was perfect. It was perfect.
But we can quickly do your DeMartini case.
Do you want to do DeMartini quickly or just go to the case you're talking about?
I'm going to tell you really quickly. It's DeMartini,
Okay.
30 seconds. So she'll
All right, go ahead. Go ahead, do DeMartini.
DeMartini means the trial courts have to be cognizant that laws change. And so this is a case about a lis pendens and about expungement of a lis pendens. And in 1992, the statute was changed, okay? And probable validity means it is more likely than not the claimant will obtain a judgment against the defendant. Okay, that's CCP 405.3. Well, what was important is you have to show, under the current law, preponderance of evidence, more likely than not to prevail, meaning win. And so the amended statute requires basically a mini trial on the merits, okay, as to the probable validity of the finding, not maybe the old law, which is more, they said was like a quasi demur, okay? You have to like really show some evidence that you're going to win, okay? That's what the whole case was about. I don't know why the underlying court didn't get it, but that's DeMartini in 1 minute.
And I'm going to do another 1 minute on DeMartini, which was part of the claim in DeMartini had to do with the law says if you're going to file a second lis pendens, you need to get prior court approval if you're going to do so. One of the issues in DeMartini was, well, it really was a different legal action, but it involved the same property, the same plaintiff, and the same defendant. And the court said, yeah, that statute applies. Before you filed your second lis pendens, you needed to apply to the court first. Now, once that application was made, then you need to apply the rules that Michael was talking about. You need to have that second mini trial. But I think DiMartini at least was good in that it clarified that one issue if there was any ambiguity, right, about filing a second lis pendens, which is that rule can apply even if it is a different legal action, especially if it involves the same parties and the same property. What do you know? We did DiMartini really quickly, so let's go
30
on.
30 seconds,
Yeah,
please.
absolutely.
Read the statute carefully, because if you don't follow it exactly, it's void. Just be aware of that.
Well,
thank
yeah,
you.
I mean, we could go off about lis pendens. You know, this is what I deal with like all the time about, there's also the deal about when you send your certified letter, when you record it, when you file it with the court. It's a lot of stuff. The only thing is, from a practical point, I've never had a judge say I'm expunging it because of those technical requirements not being followed. Judges don't care about that. Right?
Well, why do they expunge it then, Michael?
Oh, we expunge it because of other reasons. But so they expunge it because, like I said, substantively, they look at it and they go, what's your claim again? What really happened? No. Okay. But the technical requirements of when it's filed, I've never ever had a court expunge it because of the filing and recording requirements.
So in your experience, they're looking at the probable validity rather than the procedural mechanism. Okay.
Yes.
All right. Well, great. Thank you. Thank you both. Let's move on. Let's move on to Romero, a case that was decided earlier this month. Don't have an official site for it yet. California Supreme Court case. Michael, you started talking about this case, so why don't you just quickly go through, the summary?
Okay.
And then let's allow some time.
I will.
Go ahead. Sometimes we can do our announcements. Okay.
Okay. So on this case, I want all of the viewers afterwards, go to Zillow or Google, whatever you want to, Redfin, whatever company you like, the property address. It's in the opinion. If you see what this house looks like, and I'll just say that under Zillow, because I'm staring at my screen right now, its current estimated value says $1.2 million. But values have gone up a lot. Like even the last 30 days has went up about $30,000. This is a small, ordinary house, and you can actually see where the dispute happened, where the block wall is. Okay, you got to see what's going on and how these people went crazy on this case. So let's talk about the craziness of this case. It's about 5 primary types of easements, I guess. Okay, so Romero involves implied easements and an equitable easement. Okay, both are on the difficult side to obtain. Okay, implied easements are not favored in the law. Okay, it's really when you have it's out of necessity, and the people all kind of expected, like they had a right to use that property. Either build the wall there, put their driveway there, whatever it was. They had a really clear expectation. And this case went all the way up to the California Supreme Court. It's also interesting how on the remand, this is something I didn't know, the remand goes actually to the Court of Appeal, not back down to the trial court, but to the Court of Appeal. I don't know did you know that, Neil?
No.
It says I never saw it before. Anyway, they went through this case where the trial court was really, really smart, I think, how they did it. But the issue was, what is the evidentiary standard for recognizing an implied easement? Because all of the jurisprudence has been, it's a very, very high burden, very, very high. You need clear.
And Michael, before you go on with that, right? Because one of the issues with implied easements, and I remember learning this a long time ago, that you cannot have an exclusive implied easement because that is the functional equivalent of saying you got adverse possession, right? Because you're denying the other party all use of their land, or functionally all use of their land, But here we have a block wall. You are stopping the other party from using their land, but the court, used this approach. Go ahead, Michael.
No, that's exactly what led to this, because historically block walls, you start to get different issues about encroachments and statutes of limitation. Is that a trespass? Is that a permanent trespass? Is it a temporary trespass? And I can go off about that. That's like a whole nother discussion. What is temporary, what's permanent? And it'll blow your mind about some cases with the wrong facts, but the head note says something and it gets adopted by another court and it gets all twisted. But in this case, that's what happened. Someone had a driveway. Actually, this is how it started. In the 1940s, these people owned two adjacent lots. They built a home on one of them. The other one was just sitting there vacant. It's in Sierra Madre. Okay, it's kind of like out in the hilly-ish areas. And so they built their driveway. They built the area for plants and a garden, and they put a block wall, and it extended all the way to the back of the property. So this block wall maybe went 8 feet over, but went back like about 100 feet. So I think it was around 13% of the neighboring property, but it was the same owner of both lots. 30 years later or so, the son of the owner said, hey, could we build a house on that empty lot next door, and I'm going to sell it, do it for like some profit. And so the parents are like, cool, fine, let's do it. Well, the parents are still living apparently in that one house. They're not interested in changing their driveway or the block wall. They didn't care about the property line because they owned both sides. And that was the issue here, is because if they would have measured the property line, their driveway would have been really small. Well, these guys apply for a lot line adjustment, and the decision says they don't know why, but when they applied for a lot line adjustment, the city just never finished it. And they issued the permit for the building, but I could see how, a few decades ago, things were more informal. They got the permit, built the other house, sold it off. That was that. Got transferred a couple times. But then we got a new owner. Well, both properties have new owners. The original person that built that in the 40s is gone, sold their house a couple times. The new
Michael,
yeah,
3 minutes.
okay.
3 minutes.
So we'll jump to it. So this case about the implied easement, they just wanted to focus on the intent, and they said it was crystal clear that the intent of the original owners was to have that property line where it was, even though it wasn't official. And they talked about wild deed. A wild deed is when someone is on their deed writing this property plus an 8-foot by 97-foot section, but guess what? They never really owned that section, so they put it in their deed, but it doesn't count. So that was wild deed. They talk about agreed boundary doctrine, which you would think might apply, but that doesn't apply because there was one person, not two people, making the agreed boundary. But they said it was critical to have this driveway and the wall, otherwise the driveway would be of no use. Okay, and basically they just went through it, look at the intent of the parties, kind of go through the bullshit, forget about that. What did the parties really intend? Well, when the son and the parents decided we're going to build a house next door, this is where we want the boundary to be, and they stuck to it. So that's this case. It's nice.
And all of that might have been fine if it was still the original owner, but it wasn't. Fred, I got a question for you, which ties back to your mediation practice, right? So here there was an original demand for $300,000. Ultimately, the damage that were awarded were $69,000. How much does it cost, just a rough estimate, to bring a case all the way up to the California Supreme Court?
I would say probably about $300,000 if you got, assuming a $400 an hour attorney, which would be low. I mean, it would be a lot of fees to get there, litigating it. I mean, just to go through a trial would be 150 to 200,000, but then to do the appellate briefs and everything, yeah, I would say that the investment was pretty high in order to get that return.
Yeah. Okay.
This seems like a case where there's a lawyer involved, like a family lawyer, but they didn't mention that. Like neither party, they said, was a lawyer. But this is such an unproductive waste of time and money case.
Unfortunately. Well, here we are talking about time and money. We're at the end of our time. We'll talk about Riddick next month when we come back. We're going to be on our usual time next month, which is the third Thursday of the month. Michael and I had a conflict this month, but next month we're back to our third Thursday. Again, look at this screen. If you want to do a webinar for Real Property Section, contact Marty. If you want to write a short article for our monthly e-news, contact Eli. And if you've got a good long article, something really substantive, law review type, contact Brian. We hope to see a lot of you at our Real Property retreat next month in Palm Desert. And we're also going to talk about next month. There's a really good landlord case about when is a landlord really responsible for a tenant's vicious dog. Hey, thanks, Fred, for joining us. Sorry we had to cut you off. Michael, as
I figure
usual,
I'll never be invited back again, but thank you.
Thank you.
Not true. Like I said, you answered all our questions without us even having to ask them. So thank you, everybody, for another What's Up With Us. Check your emails because you'll be getting that certificate. Say, hey, every hour is an hour less that you have to get somewhere else. Bye, everybody. See you next
Bye.
month.
Thank you.
Bye-bye. Thank you.
Thank you. Bye.
Great to see you.